I extend a very warm welcome to all the participants and our learned speaker to the 85th webinar on Company, Securities and Insolvency Law, recap of recent regulatory and legal updates and Q&A, session on key issues. This is being organized by Corporate Professional as a part of its knowledge sharing initiative. Friends, as you are aware, that we have decided that every first Friday of the month, we will cover all the changes, all the regulatory aspects and the important case laws which has come in the last month, we will discuss. So based on your suggestion, we are starting this particular type of webinar where we will cover most of the issues. And basically our point is that we will discuss the factual aspects, what is the law has come, what is the impact of this law, and what are the issues in this law, and if there is any need of changes required, we suggest to give the government. So this is our second program. We started on April 22nd, and then now this is the second in the first week of May. The learned speaker will also deal with various queries which we will receive from the public and we will discuss. Because this time the amendments and regulatory aspects was less, so we have taken up 3 topics, that is the related party transaction, independent director and voluntary winding up, because these are the 3 topics which are always you can do the program and so many queries are there. And today to discuss all these issues, we have a learned speaker, Mr. Amit Gupta, who is a practicing company secretary, insolvency professional. We have Ms. Anjali Agrawal, partner, head capital market, corporate professional. We have Mr. G.P. Madan, founder of Madan Law Office and M&A Task Force and co-chair of SOCHR. Mr. Manoj Kumar, partner, head M&A and transaction corporate professional. Mr. Nitesh Ratwal, associate partner, corporate affairs and compliance, corporate professional. Mr. S. Sudhakar, vice president, corporate secretarial, Reliance Industry. So these are the speakers, those who are dealing day and night in these topics, and what are the changes which has come out by the government, SEBI, MCA, insolvency or RBI, that we are covering. The program structure will be like this. First, Nitesh will cover and he will discuss about the changes in company law and certain issues related to RPT. Then we will discuss about the security law, then we'll discuss insolvency law. And all the speakers, those who will discuss, they will give the factual things, and then we'll see impact, issues and suggestion to government. So now I invite Nitesh Ratwal to give presentation. Nitesh.
We can't hear you, Nitesh. You're on mute. Unmute yourself.
Yeah, good morning to all of you, all the listeners and all my co-panelists. So here, thank you, Pawan sir, for giving me this opportunity to talk about all the regulatory updates which happened in the last month. So I will take you to the slide in which all the regulatory update I will show you, which released on the last month. So there's an amendment.
Nitesh, change it in slide share mode, please. Slide share mode.
Yeah. Is it fine? Okay.
Go ahead.
Yeah. So let's start with the first update. The first update is regarding that inspection, the inspection of registers of members, debenture holders, and security holders. So it's been a open privacy. There's no such privacy if we talk about the inspection. Once you get the inspection, you get all the details of the shareholders or the person. So there's a breach of the, you can say, a confidentiality information, because everything you can find in the registers, like his register, the address of the shareholder, security holders, his personal email ID. Now it's UDIN also there, it's PAN number. So all these are the confidential information which anybody can take, because it is open to every person, not being only a members who can inspect the register of securities or shareholder, any kind of even of debenture holders. You can ask for any information, they will provide all kind of information if somebody wants to inspect and get the details out of it. So so many complaints have been lodged that they are receiving so many emails from unknown person. They have their PAN number, UDIN, and all those details, which is very uh, creating a issue, or making the breaching of the privacy of that individual. So with this, they have amended this inspection criteria. They are saying that you can the inspection cannot be made of taking the information or even inspecting the register. Only the name will be reflected. They will not show any email ID of that debenture holder, security holder. UDIN also cannot be. You cannot inspect, or including the PAN. So all these personal details are not shown to you while you do the inspection. The next is the there's a so as you are aware that whenever you take the loan from the banks, you need to create a charge on the assets in which you the security is in which there's a security over the assets of the company or its holding company or associate or a subsidiary. So charge needs to be created. But what about the bank? If the bank takes a loan from the RBI, so they are somehow cover under this section 77 of the Companies Act, where they also need to get it registered. So so the banks says that they are ordinary take the loan from the RBI, so they need the exemption, because taking loan from the RBI is not something which happens for an ordinary business. So there is an exemption to get the registration of charges if the loan is taken by the banking company from the RBI. The next is that as you are aware, there is a press note released by the government of India in press note number 3 2020, which talks of taking the approval of the government if any foreign national or any foreign body corporate makes investment into the company, and that foreign national or body corporate is a neighboring state, is a neighboring country, then you need to take the approval of the government. So on this premise, they are come out. There's a change in the rule of the Companies Act, which says that whenever there is a transfer of shares from resident to non-resident, non-resident to resident, if there's a approval required under the FEMA regulation, read with that press note number 3, then you need to attach that approval with the share transfer form if there's a approval required. It means if there's a approval required, you need to first take the government approval, and then your share transfer would be registered. There's also a change. There's also a change in the Nidhi company. As you are aware, that Nidhi company is a mutual benefit company where the members of the Nidhi company take loan amongst the members. So in this regard, there's a specific requirement that whenever you get the incorporation of a Nidhi company, you have to give some declaration that once your company is incorporated, you will take the approval of the central government to be registered, to declare that company as a Nidhi company in the official gazette. So that declaration needs to be filed along with the incorporation. So there's some good changes in the Nidhi company. So the the net own fund of the Nidhi company has been increased to 20 lakh. The paid up share capital has also been increased. And the Nidhi company has to apply to the central government to be declared itself as a Nidhi company within 120 days of the incorporation. Earlier, this period is of 1 year. Now that has been reduced to 120 days. So you need to get the approval of the central government to be called as a Nidhi company in 120 days of the date of the incorporation. And thereafter you need to apply to the ROC for commencement of business. It means you cannot commence business before approval of the central government. So there's also a restriction placed that you cannot give loan to your own members after taking the loan from the banks or PFI. So there cannot be a process that since Nidhi company provides loan to your members, so you cannot take that route that you take the loan from the banks and then you provide loans to your members. So there cannot be any kind of the process in this regard. So there's a complete prohibition. So you have to take loan from another member and give it to the another member. So bank loans cannot be used. And with respect to the branch office of a Nidhi company, so there's no provision of the closure of the branch office. So under the new rules, you have to take the approval of the RD if any Nidhi company wants to close its branch office. And the another rule is that you may find many offices which is not a branch office, only a representative office. So Nidhi company are not allowed to open such kind of offices. Either you have to declare it as a corporate office or a branch office. If any other office is there in the name of the company, it has to be closed. It has to be closed within the 6 months.
Okay, Nitesh.
Yeah.
Go back to first slides. So now these are the changes in company law. So I have few queries which all learned speaker can give. I will start with Amit. Amit, just tell me now. This is right that some people are saying people are misutilizing the address, email address, PAN number, or unique identification. But suppose I'm a shareholder and I want to talk to other shareholder to take up some matter because company is doing something wrong. Okay. Now, if I'm getting the list of shareholders without any contact detail, tell me how I will talk to them. Is it not indirectly helping companies to face the consequences of the combined strength of the shareholder?
The point that you have raised may be valid from one of the aspects, because this particular issue has got two coins. It is correct that the point that you have raised, the amendment will pose certain challenges to the shareholders who want to get connected to the other peer shareholder for taking up certain matters. But over a period of time, what has been understood by the practices prevailing in the market, this inspection provision has been highly misused, especially by the peoples who have the much larger influence in the market. They used to get the data from the company, talk to these small investors, misguide them, and get the shares registered in their favor. Of course, transfer after paying consideration, whatever way. But these investors were many times having no access to the right information. So they were having challenges in respect of these communications, what were being coming from these so-called influential people. So I think it's a step in a right direction. The point that you have raised may be valid, and maybe there may be some alternative way to work out. But I'll raise one more issue. How the infrastructure that the companies presently have, they will be able to prevent the inspection of this record. Let us go practical, because my register of member is maintained in the format what the law has prescribed so far. Are we saying that we have to redo the whole exercise unless we are doing it in the electronic format? There, so I have the possibility that I can hide these information and field, I can present the information, whatever is permissible. But think about the situation where I am maintaining the record physically and my register contains email ID, address, unique identification number, PAN number. How I'll be able to hide that data from the register of member is a $1 million question. I am not yet having the answer for the same, but I'm just flagging. Are we saying that we have to redo the whole exercise, and so that we can bifurcate the register as to, with regard to information, what can be shared, what cannot be shared?
So one more question, Amit. Like I have paid the amount and I am coming to the company, I can see the register. That is allowed. Now I can note down also, or I can take a photocopy. So the question is, now on this basis, your noting is also not allowed, okay? Because you have to hide these things. And the practical point which you are saying, this is also practically correct, that how you will hide from that register. So you have to make it all registered again.
Correct. That's a practical challenge that companies are going to face. Making law is one part, but when it comes to implementation, unless and until the registers are in digital format, which are there in many of the cases as far as the large corporates are concerned, they may not have that difficulty, but the small corporates who are maintaining the records still in their physical format may have that difficulty.
And one more thing, because this is a order of the government that you have to protect the privacy of shareholder. So this is not the may. It has to, every company shall follow this practice. So that means every company has to change its physical register, or if they have a digital, then they have to make it format in such a manner that they have to provide the information with hiding all these things.
It is very well possible. It is not that difficult, but we are just flagging that the companies have to take some proactive steps to do all these changes so that the inspection is limited only to the permitted data.
Okay. So any other points?
Yes, in the regulatory update.
No. Let us go back.
Okay.
Anybody, Manoj, you want to say? Anjali, anybody wants to say anything on this? Okay. Amit, is this restriction of hiding detail exempted for government agency? How will agencies such EDS, FIO get detail? I think they are exempted. They can get any information.
Yeah, absolutely, because that's a inquiry investigation. 206 and onward section provide all the freedom to them to get all these information. This is only limited to the shareholder inspection.
Yeah. Okay. So next question, next point. Nitesh, next slide.
So here I'll agree with what Amit was trying to say, that otherwise it was really creating a lot of nuisance, in the sense that anybody used to ask for any of the information pertaining to the members, and then they used to circulate whatever mails they wanted to those people, and it was creating a ruckus for the company. So at least this way only limited information will be given to any person seeking inspection. So to some extent, the problems being created will be resolved.
It has a both way, Anjali, both way, because Amit has given a point that people are going to the companies and shareholder, asking them, please give your shares. That is number one. Suppose they want to utilize this data. Number three point, which I have mentioned, that I want to fight and I want to take the help of other shareholder. I don't have address, so I can't take advantage. So this issue government has to work out. Either in a special case, they can move to the NCLT and then they give the undertaking that they will not use for any other purpose. They can do it certain things. Am I right, Amit?
Yes, absolutely.
Or government can give 100, 200, 500 shareholders data which you require, and not the entire data of 1 lakh, 2 lakh, 3 lakh shareholders. Okay.
Sir, but I think with the inspection, with this kind of restriction, I do not think anything is left for the inspection, because in the annual return which the company used to file, you will find the name of the shareholder. So I do not think if under the inspection anything is left for the person who wish to inspect, because he wants to inspect to get these details. Because if you see that many companies are up with the ESOP, so many employees who does not know the right of the as a shareholder, many employees, they just want to induce those employees to get transfer in my own name, so that I will negotiate with the promoter or the founder to get the shares at the higher valuation.
Okay. Next slide.
Yeah. Yeah.
Next slide, Nitesh. Next slide, not this. Go back to the original. Before, after this MCA amendment, you go to charges.
Okay.
I'm covering here first all the questions. Acha. So this charge issue, they have given the exemption to RBI related thing. Any point in this, Amit, Anjali, Manoj Koi? Any point in this? Any issue will come? Any impact on this?
I'm not able to understand as to which charges are required to be created in favor of Reserve Bank of India.
That's why I was also thinking. But must be government has must have received some representation.
No, sir. There are collaterals which the RBI asked for it, like government securities, which the private banks has bought it, the bonds, government bonds, the commercial what you call certificates, which the government issue from time to time. So RBI asked for the collaterals, which you need to get it, which you need to set aside for the RBI. So if you go by the regulations or go by the rules, you need to get it registered as a charge on the MCA portal. With this exemption in place, you need not to file any kind of charge. So there is a provision in the RBI Act.
Yeah. So if I can supplement to Nitesh, what I can visualize is because now small finance bank and the private banks are there, and they are also required to comply with the provisions of the Companies Act. So maybe in these situations, you are required to provide a security in favor of the Reserve Bank. So
yeah,
to that limited extent, this provision might have an impact. But I'm yet to.
Yes, it is only relating to government bonds and government or bank securities. Banks raising fund from RBI, certain class of banks and financial institutions.
Okay.
Next slide.
Next slide. Now this is one SH4. So Nitesh, why this SH4 they are prescribing and want to change it?
Sir, if we are aware that initially at the first lockdown, so I will not name any particular country. So government of India thought that some neighboring countries wish to, because the situation was not well. So some neighboring countries would capitalize on this advantages by taking over the Indian company. So they have put the restriction by way of press note 3 that any of the foreign national, especially the neighboring countries, which we have 7 neighboring countries, if they wish to invest in the company, they need to get the specific government approval. So on the same premises, the MCA has also provided one only declaration. It is not saying that you again go to the RBI, again go to the approval route. It just says if you have the approval, or it is required, that approval is required in case of a transfer. If you are a foreign national of all those 7 countries, then attach that approval if you have taken it.
So they have covered both the things, like amendment of prospectus, allotment of securities, and the transfer. So if you are going for transfer of existing shares, then you have to take this approval before filing SH4. Am I right?
Yeah.
And then second is and the second point, which
it is with respect to all kind of transfer of shares where government of India's approval is required. So for that, there is a specific now declaration whether any if it is a foreign transaction, FDI transaction, then a specific declaration whether approval was required or not. If yes, then approval was taken and or not. That is the only thing they are asking for. Not restricted to only the neighboring country. It is generally it is asking.
Okay. So so next point.
I was just submitting that this is the extra layer of caution that the government has created, because FEMA law was already there, and that is already there in place, which primarily deals with the issue of security to these peoples and transfer of these securities. Now, what has happened, perhaps the government has conducted some investigation, and we may be aware that government is in process of launching prosecution against many of the professionals and the companies also. So in that backdrop, government has taken a cautionary step that the law should be amended to ensure that the professional who is involved and who is doing that certification work, he should also be cautious that any such type of allotment not take place which are restricted otherwise in the FEMA, which in any case were required to be followed. There was no need, but I think to create just awareness and the caution, the MCA has came out with these amendments. I think indeed they are welcome, because when there is a specific requirement, then you become extra alert. Maybe otherwise you can ignore the FEMA provision, but if there is a specific mention in the declaration, then you become little cautious.
Yes.
Okay. So now this is transfer. Go to the next slide, Nitesh. And this is, they are saying that when you are go back. Nidhi se pehle jao. Okay, one more amendment is there, na, prospectus and allotment.
Yeah.
That came yesterday.
So they have covered both the things for these 7 neighboring countries. So they have precaution. If you are allotting, then you have to take private PSA 4 you have to file, and if you are transferring, then SH4 you have to do. Okay.
Yes, sir.
Both way they have restricted. Both way they have restricted all these countries, which we have seen, and we are aware that China's issue, which all the other countries, not on India, but other European countries also restricted when they realized that due to COVID, the share price has gone down, and they were buying these shares. So they have asked for the approval. Okay. But the question is, this is the restriction government has done earlier. So what is the need to do now? So this is only precautionary or something, some layer they have created.
That is what I am saying, because you may be aware, ministry was having some information in respect of some huge scam they are suspecting from the cross border, especially China. So they have conducted an investigation, and they have found certain discrepancies also in respect of these companies, and the professionals have also been subjected to certain disciplinary proceedings and the enforcement actions as well. So in that backdrop, it's a suggestive change that the ministry was required to undertake from the, I think requirement came from the different department, and the ministry was just making implementation of the same. Even in this matter also, the China investigation initiated on the directive of Home Affairs, and later on the investigation was done, and prima facie things were found not in order. So on that direction only, it is just a implementation of the instructions of the other ministry.
Okay. Next. Before this, there is one more amendment which I have seen this. Amit, they have now, they are saying companies may hold EGM through video conferencing, and they have extended date of 31st December 2022. So EGM and AGM both can be there.
Now, only one issue is there. Why this amendment was required? Because the circular that came earlier in December 2021 granted the permission to the companies to hold their AGM up to 30th of June 2022 by video conferencing and other audio visual mode, whatever are permitted. That date was coming very near, and 30th June was just reaching out. If any company has to plan their AGM in 30th of June, that means they should plan well in April, May, so that they can hold the AGM. So request was made to the ministry that if you are planning to give the extension, that should come today. Otherwise, if we are delayed by 15 or 1 month more, then the purpose will be defeated. Every company will be not be having the opportunity to hold that meeting through EGM, and they will through VC, and they will have to plan it alternatively. So that is just extension of the previous position that started in 2020 during the COVID scenario. That same circular has continued. Now, there is one challenge in respect of a listed entity. Listed entity have to comply with the regulation 36, which says that if you have a physical shareholder, then compulsorily you have to send the annual report by physical mode. That exemption SEBI has not given so far. Now, though MCA circular allows me to follow the MCA circular issued in 2020 and hold meeting through video conferencing by sending the annual report only to the email IDs which are registered, or you allow the facility to register the email ID and send it across to them. There was a specific process which has been specified. Now, if I am a listed entity, after 31st of December 2021, the circular has not been extended by the SEBI. So all listed entities which were having the financial year closed at 31st of December 2021, which were first in line to hold the AGM, they were facing that difficulty. They had made perhaps the representation also, but so far we have not received. I think I'll request your good office to make a pursuance with the SEBI also, that this is a genuine problem. If we are not giving the extension of that circular which was issued earlier, which was waiving the requirement of sending the physical annual report, I think that would be a great support to the corporate. Otherwise, you are giving partially the relief to these listed entities by way of holding the AGM in VC mode, but still annual reports are required to be printed and sent for all those physical shareholders.
So we have two issues now. One issue is that the annual report by email. Second is the VC, the EGM and AGM through VC. Now I'm asking this question: why can't we make permanent?
Sir, the CLC committee has already recommended that to make it a norm, to make it in a rule, so that nobody wait for the circular exemption. So I think in the coming months or in the current this year, it will be a part of our rule.
Okay, one more amendment they have done. They are clarifying that this VC meeting meeting is different, but if you are delaying, then the penalty and other prosecution will be there. So they are clarifying.
I think you are talking about the para 2 of the circular.
Yes.
Saying this should not be considered as extension of time for holding the AGM. But you should not misunderstand that your AGM holding time has been extended to 31st of December. That is only clarification in nature, nothing else.
Yes. So the confusion has created because of the timeline given 31st of December 2022. So to avoid that confusion, that you can hold AGM through VC up till 31st of December 2022. That was not the intent. It was for any company which has taken extension, specific extension. They can go up to 31st of December. Without approval, it is the 30th September will be the due date in any case.
Only one point I would like to flag, which can be taken up to the ministry for clarification. What about the annual general meeting of companies for previous year? Let's say there are many government companies who have not completed the AGM. Let us say there is a government company which is now holding the AGM for the year ended 31st March 2019 or for 2020 or for that matter 2021. Is that circular giving you the to hold that through VC? Prima facie intent.
Yeah, I have joined already.
But the circular,
Sure, I have already joined.
so many words does not say so.
Amit, I think if a company, if this is the law which is allowing, then we can do this because law is allowing up to 22nd. So today I'm doing it today. The problem is persist today. So there is a possibility if I do the harmonized interpretation, something is connected to the old one which I am going to do today. And today is the problem. So that's why I can do the older years AGM or EGM through this mode also. This is
Yes, I think time is crucial. Not the year for which it is being made. The meeting which is being held between this period should be can be through VC, not for which year this AGM is. It is not making any difference.
Yeah.
But actually, the problem is the words because it says to allow the companies whose AGM are due in year 2022.
Okay. Sudhakar, you have welcome. There is
Hi, good evening.
a question going on.
Yeah, I could make it. See, I agree with the person who spoke to me previously that according to me, the AGMs, irrespective of the year, it can be held up to 31st December 2022 by way of a video conferencing. That means in a virtual mode.
Yeah.
That is the intention.
Yeah.
Suppose words, okay, one can play with the words either way. But according to me, the intention of MCA is because considering the situation, considering the circumstances, what they say is you can hold the meetings virtually up to 31st December 2020.
So the clarity is this: if they have extended up to 22nd, December 22nd, they are not extending the time. You have to follow during your.
That is correct. Yes, absolutely.
Yeah. And third is which Amit has raised. In case you have to conduct a meeting of previous year because of some reason you are not able to do it, you can do through the video conferencing. That is the consensus which has come.
Correct.
Okay.
Absolutely.
And Amit has raised a fourth point that meetings they have allowed, but the clarity on annual report sending by email is not clear. That is mixed. So that can also be clear. So it can be.
But to my understanding, even in Indian corporate structure presently, there are many shareholders who are still holding shares in physical form, and they still feel comfortable receiving a hard document. So if SEBI gives this exemption that no annual reports are needed to be sent to the physical shareholders, they will not be getting any document regarding the company. And probably that's the reason why SEBI has not extended this requirement. COVID ke time they gave that temporary relaxation, but uske baad they have not given this exemption.
Actually, as a shareholder, you can ask.
Where you are saving a lot of environment.
I agree. I am in with that. Yes, I agree with that.
But Anjali,
by default, we make the provision that it will go by email. If some shareholder want physical copy, let the company print the physical copy and send it across. So it should be by exception. It should not be by default. Presently, it is by default.
But Amit, even in companies as on date also, there are at least 500 to 1,000 shareholders who are holding shares in physical. I agree. I am totally in it. There is an environmental hazard to this issue with printing of so many annual reports. But jiske paas physical shares hai, he would be wanting that I should get some information about my company.
Anjali, holding the shares in physical form and receiving the annual report through email are two different issues. Nobody is stopping this shareholder who is holding the shares in physical form to provide his email ID to the company.
I agree, sir.
The company can send it through email.
Yes, surely.
His worry is not that he doesn't want to receive the annual report through email. His worry is he does not want his shares to be in demat format, that's all.
Right.
So let him keep the share in demat format, let him keep receiving the annual report through email.
Yeah, but this generation, the generation who was holding shares in physical, they might not even be having an email ID. That's the point.
The government doesn't want those shareholders.
Okay. Yeah, that's right. That's right. But
Right.
So they have this system also that any shareholder wants, they can take. Okay. So Sudhakar, you are the right example. How much money and how much environment you have saved by not sending by physical mode?
I can say a few crores.
No. I'm not bothered about the crores. I'm bothered about the environment. How much environment you have saved?
See, that in fact, I need to work out that particular thing, okay, by how much is environment and all, but I can definitely say a few thousand trees if you want like that. If you want in monetary terms, few crores. If you want how many trees you can save, I can say certainly few thousands.
Okay, so next time in your balance sheet, in your annual report, you can write that by email, we are saving this. Okay. Now, next point is Nidhi. Now, this Nidhi companies, though it is a not a general parlance thing, and very few people are working on this, and the government is doing the limit they are increasing, and various things they are tightening. Anybody who is handling the Nidhi can give the background. Yeah, Amit.
Sir, what has happened? If we recall the provisions of Companies Act 1956, the provision of Nidhi companies was dealt by central government directly. Only with the approval of central government, company could get the status declared as Nidhi and do with the business of Nidhi companies. Effective from 1st April 2014, when the Companies Act 2013 got notified, the requirement of approval of central government regarding declaration of company as a Nidhi company by notification in the official gazette was done away. It was only in 2019, perhaps I am remembering the date correctly, then it was 15th of August 2019, when the government took a U-turn. When several complaints were made from various investors, because if you see the number of Nidhi companies, what were existing on 31st of March 2014 were only 1,000. And in 2019, the number was more than 10,000. Why number increased? Because there was no requirement of notification in official gazette, and there was no requirement of following a cumbersome process which was there earlier. So every company was trying to find out a way, and because you were allowed to deal with what the Nidhi company does. Nidhi company does a very unique thing with regard to the banking, that they can open a saving bank account. They can open a fixed deposit account. They can open a recurring deposit account only of a member. And they can even give the money on loan also, but only the secured money. So you are in a way doing a para-banking kind of activity, which otherwise is allowed only for NBFC, not otherwise. Now, by Nidhi companies having no regulatory check, all these companies mushroomed, because they knew that they are now no longer required to take the approval of RBI with regard to NBFC. They can simply make the person as a member and do whatever money lending and whatever fixed deposit or RD is required to be done. Then government got an alert, they made an amendment, and they mandated there will be a requirement that in so-and-so timeline, you will be required to take the approval of central government, and on prescribed fulfillment of condition, only you will be allowed. Now, recently, this provision was there, but perhaps this provision was not getting implemented, and NDS4 form, which was for the purpose of seeking the government approval, was not getting approved at all because the policy decision was not there in the ministry. Recently, government has taken a policy decision. They have prescribed the criteria as to which all companies which will be considered fit for the purpose of giving the license of Nidhi. So they have prescribed that higher net worth will be prescribed. The fit and proper person condition has now been introduced in the Nidhi companies purview also. So all that is good. Only point is that there are many teething issues with regard to the Nidhi companies which government should resolve. I'll tell few of them, like unless you file NDH4, you are not allowed to upload any SS7 for increase in capital. Let us assume a company which has been incorporated with a paid up capital of rupees 5 lakh, which is allowed, and you have not yet got NDH4 approved. How you will increase your capital, because SS7 form is not getting through because of the egg and chicken story. Unless your NDH4 goes and approved, SS7 will not come, and unless SS7 goes, your NDH4 is not going. So I'm saying these are the teething issues which ministry should consider. I'll not take much of the time because this topic may not be, because we have much more topic of the interest. So, but certainly it requires attention of the government. It needs to be brought to the notice of the government that the issues which are revolving around the existing nidhis needs to be taken care, and the clarity should be given as to what is the action required to be taken in respect of existing nidhis. Though they have provided a timeline of 18 months that they should fulfill the condition, but practically implementation is seemingly impossible unless and until government comes out with some clarification.
Sir, it has to be seen with the steps taken by the RBI recently to be a more vigilant in case of NBFC, because now seeing the NBFC criteria has been tightened up, the norms has been tightened up. So why not the Nidhi company? Because the role is more or less the same.
Nitesh, you can say, but I'll see it differently. I'll say the red flag was raised way back in 2017 itself. The frauds started in respect of Nidhi companies way back. Complaints were coming to the ministry right from 2016-17 itself, right? And government amended the provisions also. But the necessary changes in the other rules were not made, which got notified very recently in the month of April itself. So implementation is now going to take place in respect of the changes what had taken place. But you are right that RBI has also tightened the norms, so government has also waken up to make necessary corrective actions in the Nidhi company. But I'll certainly agree that this is a very good model that has coexisted with the bank, with the NBFC in the society, and it's a very good model which reaches out to a last mile person in the society. So not a bad option, but government should come out with the necessary clarification so that problems are not there.
Okay. So Nitesh, now go to the securities law.
So the securities law, there's some clarification with respect to the shareholder approval for material RPT. For any kind of shareholder material RPT for which any shareholder approval is taken, then the validity of that shareholder approval or that material RPT is from one AGM to another AGM, but it shall not exceed 15 months. However, in case the shareholder approval is taken in extraordinary general meeting or postal ballot, then the validity period of such approval shall not exceed 1 year. However, the main problem is that the omnibus approval of shareholder approval, omnibus shareholder approval is not actually defined under the LODR. So it is very confusion what constitute as a omnibus approval with respect to the shareholder approval, because omnibus approval is with respect to the audit committee. which is valid for one financial year only. So there is some new concept of shareholder approval, that too is omnibus shareholder approval.
Okay, Amit, any logic, Amit, Sudhakar, or anybody can give a logic that why they are giving 1 year for EGM and 15 months for...
I'll share my view. I think Sudhakar sir can further supplement to that. What I understand, why this clarification, although I feel this clarification was not required at all. After 9/11 amendment, what SEBI did last year in respect of LODR, many of the corporate houses have reached out to SEBI after many of the listed entities have came out with their extraordinary general meeting resolutions. And these resolutions were taking the approvals for various periods ranging from 1 year to 5 years. SEBI has perhaps got an alert on that and taking a conservative view that in respect of omnibus approval, where audit committee approval is only limited for a period of 1 year. In case of Companies Act, the year has been defined as a financial year. Very clearly, there is no ambiguity. As far as LODR regulations are concerned, the omnibus approval, the period year has not been defined, although logically it should be considered as financial year only, because other way you will not be able to put any control mechanism in the company with regard to approvals. Your financial statements are prepared on the financial year basis only. So anything, any limits that you are approving, which are benchmarked to the financial year basis, are always easy to be calculated and monitored. Otherwise, it is going to be next to impossible to monitor and control that. Now, in that perhaps backdrop, SEBI in a hurry came out with a clarification that your omnibus approval, if taken at a general meeting also, will be having a validity for the period of 1 year only. Now, in case of general meeting, why they have gone to 15 months? Because they were aware that general meeting at max can stretch up to 15 months, maybe with the approval of respective registrar, or maybe otherwise also you are permitted to stretch the period beyond that period. So they have considered that if you are taking the approval of omnibus approval on any of the material omnibus related party transaction, your validity will be for the period from this AGM to other AGM, or if you have approved at extraordinary general meeting only for 1 year. To which, to my mind, there could be a situation that I am doing a omnibus related party transaction. Nitesh was highlighting as to what is the meaning of omnibus transaction. I understand omnibus transaction as a transaction which is recurring in nature, where you don't have the details with regard to certainty of transaction and maybe the quantum or value. I am doing a purchase transaction. Let's say I am into the project construction, where my production starts on the orders being received from the third party. If I don't receive the order, I will not make the procurement. So I have not made a contract with any of the related party for supply of goods, although I may be required to purchase the goods. So what I did, I went to audit committee, took the approval of audit committee for procurement of raw material up to a certain amount, maybe 1 crore, 2 crore, 10 crore, whatever it is. And if I cross that limit and the materiality threshold is breached, I am required to go for shareholder approval also. So omnibus approval has its own advantages, and it is to facilitate the corporates from repeatedly going for approval. Before I conclude, I'll just share one more point. In corporate, generally we are going for approval by two routes. One on a contract basis, one on transaction basis. contract is like I have done a contract for supply of raw material for next 1 year, 2 year, 3 year. Then that is a contract. I need not put that transaction into a omnibus approval rule. However, if I have not entered into a contract and I just simply issue the purchase order and I pay the invoice, then it is a transaction to transaction basis, because amount is not certain, quantity is not certain, value is not certain. I take the approval. Otherwise, what will be happening that every audit committee meeting, I'll be required to, or before any transaction, I need to go to audit committee, and then only I can place the purchase order. To avoid that difficulty, omnibus approval is there. There are requirements that you have to place certain information before the committee.
Okay.
I think Sudhakar sir can.
Sudhakar, can you,
Yeah.
You have any view on this particular thing?
See, in fact, according to me, there is a confusion SEBI has created as far as this omnibus approval is concerned. If we see the Companies Act, the omnibus approval, what has been given is only for the audit committee can give the omnibus approval. In fact, some people have taken a view that where the audit committee is not there, those obligations are to be discharged by the board, so the board can give the omnibus approval. In fact, I don't agree with that also, because strictly speaking, board has no power to give omnibus approval. But sometimes, yes, if the audit committee is not there, what will happen? So board may take a view like that and all. But strictly speaking, Act has not given the power to the board of directors. What the power has been given to the board is only to approve the criteria for giving the omnibus approval. And based on that, the audit committee has to give the omnibus approval. Now the question comes about the shareholders approval. When I am entering into a material related party transaction, or when my thresholds of the related party transaction crosses under the Companies Act, I have to go to the shareholders. As Amit rightly mentioned that when I'm entering into a related party transaction, there may be a contractual obligation or there may be a transactional obligation. In case of either of the one, I will go and take the shareholders approval once. And unless until there is a significant modification, I need not go back to them again and again. Suppose if I am entering into a contract with a related party transaction, which may be having a duration of 3 to 5 years or whatever time period it is, and when I am getting that contractual terms and conditions approved by the shareholders, I don't need to go back to them unless until there is a significant modification in that. Now, where is the question of this omnibus approval? That I fail to understand that. Number one, similarly, the periodicity also. Suppose when I am entering into a contractual obligation, which is having a longer duration than a year, now this particular circular has created a confusion, according to me. But in fact, the clarity is not there. That needs to be obtained. Otherwise, what happens is we may take a view which may be different to that of SEBI. And tomorrow SEBI says, look, this is not what I mean to say. Then it may be create a confusion and unnecessarily non-compliance obligations or whatever it is.
Okay, Amit,
just supplement what, just a minute. I'll take a half a minute to just put my clarification. What Sudhakar sir is saying is absolutely right. What should be the, if this circular was not there, then what would had been done by the corporate? Let us understand that first. If let us say I have to undertake an omnibus transaction every year, and let us take a value of 10 crore, which is maybe a material which is breaching the materiality threshold also. So it may be requiring, and I will be doing the omnibus approval every year. I am doing a transaction of purchase of raw material every year from one of my related party. Value is 10 crore and the transaction is falling in the radar of shareholder approval as per regulation 23(4). What I will be doing, if this regulation was in place, I will approve the transaction in audit committee for a year, omnibus approval, and I'll put it to shareholder approval without any cap of year, maybe for 3 years or maybe for 5 years. And we will mention therein that it is subject to omnibus approval of audit committee for the subsequent years. So maybe I am approving it for the year 22-23 today. For 23-24, if audit committee gives the omnibus approval, shareholder approval is accorded. automatically. You need not go to shareholder again.
Okay.
Shareholder approval is today itself. So, but
In fact, one more thing also, Amit, you may agree with me. Omnibus approval is having a time period. As far as the related party transactions, when the board is approval, there is no time period for that. Why there is a time period for omnibus approval is because the transactions are repetitive in nature. That means throughout the year they will take place. They are on year-to-year basis. They are not having over a year that the transactions are not going to be there. That's why when audit committee is giving approval on omnibus basis, that is for a financial year. Whereas when a related party transaction, which is not an omnibus basis, when audit committee is approving and recommending to the board and the board is approving, wherever shareholders approval is concerned, we are going to them. There is no time period as such, it is there.
correct. That's correct.
Okay.
Now,
Sir,
Amit, because we have
sir, एक point. So only one point. It is something similar to we have seen in the section 42, where in case of the NCD, once you get the shareholder approval, it is valid for 1 year. I think it is on the same premises, the omnibus shareholder approval for the case of the RPT, where there is no duration fixed, there is no such affirmation that that transaction will become a material, non-material. It will be the depending upon the purchase order which we carry out during the period. I think it is more likely in a case of 42 where we take the NCD approval which is valid for a year.
so I'll just flag, Pawan sir, one more issue. Let us take an example. On 30th September 2022, let us assume that I have taken a shareholder approval for 22-23, right? And that is valid from, let us say, 1st of October 2022 to 30th of September 2023, when my next AGM will happen. I'm assuming my next AGM will happen in 2023. And I have given the approval for 10 crore rupees of value. Now, because it is not linked to the financial year, maybe my transaction will get closed on 31st of March and my limit of, let's say, 4 crore is remaining. Should I consider it as a approval for my subsequent year, 23-24? Or how while transaction is approved?
Amit.
Because now the confusion that has got created is linking it to AGM or from 1 year from general meeting. It should not be there. It should be continued to be left at the financial year basis only, which is there in the Companies Act also, and in LODR, though it is not there, but it is understood as a financial year only. I think that clarity is required.
May I put it in two simple sentences? All omnibus approvals, whether material or immaterial, passed at the AGM have a validity of 15 months. All material RPTs, omnibus approval, passed at the AGM is having 15 months, passed at EGM is having 12 months validity. Why to venture into further?
I think, Madan, I think we should stop here. And
yes, that's a simple interpretation of this.
Yeah. Okay. We will move on this. Now there is one question. Is the 15 months is mentioned to cover the cases which take extension of time for holding AGM, which is maximum of 3 months?
Absolutely, it is basis is that only. SEBI has mentioned that they have made the reference of section 97 also, 96 also, with regard to the time which is allowed for extending holding of the annual general meeting. But again, I'll say to the point what Madan sir has mentioned, it has a relevance. SEBI need to go into, because unless you are able to align it with your financial year, monitoring of related party transaction is not possible.
Okay, Amit, let's
may I put it the other way from practical point of view, that all approvals taken at EGM should practically lapse at next forthcoming AGM. Actually, that has to lapse. Otherwise, within next 12 months, you are going to have one AGM only. Otherwise, if you wait till the next subsequent AGM, that will be after 12 months. Then in that case, you have to do another EGM. It's always advisable, take approval at EGM. It should lapse at AGM, pass another resolution at the AGM and let it remain for 15 months. Or AGM to AGM, that's all.
I think Madan has given a good solution. I'm moving to this. Okay, next Ritesh, next amendment, security law. Unmute yourself.
Yeah, thank you, Nitesh. Good evening, everyone. These are some amendments with regard to the listing regulations, and there have been some amendments in the ICDR regulations as well. So first amendment, which came during the month of April with regard to the listing regulations, was that standard operating procedures for dispute resolution should be available under the stock exchange arbitration mechanism. Under regulation 40 of the listing regulations, there is a mention that any dispute should be resolved through the arbitration mechanism, but there was no such methodology given therein. Now, with effect from 1st June 2022, stock exchanges have been directed by SEBI to put in place this SOP for the arbitration mechanism, and these will contain provisions with regard to corporate benefits like dividends or bonus shares or rights entitlements, and various other share related matters. Nitesh, next.
Any point in this? I think this is a SOP is good.
Clarity, yeah.
This dispute can be solved.
Nitesh, I think we have moved 2 slides. There is one more slide before this, no? Okay, another part of this is that RTAs will be a part of, because RTAs are in a big way the part of the entire process pertaining to shares. So RTAs will be a part of that SOP mechanism. The next amendment is with regard to amendment in Schedule 7 of the listing regulations. Schedule 7 deals with the procedures relating to transfer and transmission of shares, although it has been there earlier as well. But first of all, the word transmission was not there in the heading. They have added that. That's a minor thing. But one important provision that they have brought in is that even transmission of shares now will take place only in demat mode. That means a father holding certain shares in physical, he passed away, his shares to be transmitted to the legal heirs. That will not be possible in physical mode anymore. That will have to be done in the demat mode only. That is one important change which has come in.
Anjali, it means that share first it will be transferred, but when the
no, so there is a procedure given therein wherein the child will have to have the his own demat account, wherein those shares would ultimately be transferred only in the demat mode. So physical certificate will not be issued.
First, I will submit physical shares of my mother to the company. Company will transfer in my name, but it will immediately convert into demat form.
Demat mode.
Okay.
Yeah.
Sagar, any issue you are finding in this?
No, I don't find any issue in this, because the only thing is they have made it mandatory. Otherwise, the procedures are already established as far as
agreed.
is concerned.
Anjali, this gives answer to your erstwhile observation. The government wants only shareholders who are
agreed, sir. Totally agree with that.
Okay, Anjali, once changes in ICDR also, what is this ICDR changes which government has given?
Nitesh, next slide, please. So, with regard to the public issues through the book build process, under the book build process, there is a provision that at least 15% of the issue size has to be allocated for the non-institutional investors. Under the present law, there is no further bifurcation after that. This is the only requirement. But now they have further bifurcated it on the basis of application size, that in case of application size of more than 10 lakh and less than more than 2 lakh and less than 10 lakh rupees, at least 1/3 portion of the allocation is needed to be reserved for such applicants. And for application size of more than 10 lakh, 2/3 has to be reserved. This bifurcation was earlier not there. A question may arise, why this 2 lakh rupees? Why not less than 2 lakh? Because then the applicant will fall within the ambit of the retail investor. Now, another clause which they have amended is Regulation 145 of the ICDR regulations, which says that allotment of securities to each of these non-institutional investors shall not be less than the minimum application size of theirs, of course, subject to the availability of shares in such category, and the remaining shares, if any, if remain in any of the above categories, they can be allocated proportionately to the next category in accordance with Schedule 13, which mandates certain conditions. Nitesh, next. Yeah. So any comments on that?
Actually, this is a clarification.
Yeah.
I don't think. Nitesh, next. Manoj.
I think Pavanji, this LIC issue proves that if you approach SEBI, SEBI can provide any sort of relaxation. SEBI can even order opening of the banks on Sundays.
No, SEBI can provide only in case of government or not for all companies.
Approach kare, you never know. Approach kare, mil jaye shayad relaxation.
Yeah, that's right. Buildings. Okay, so now
and for these provisions will be applicable for issue sizes less than 10,000 crores with effect from 1st April 22. They have become mandatory, but for, as Madan sir said, for issues like LIC, that is more than 10,000 crores, they'll become effective from 1st July 22. Abhi applicable nahi hua hai unke liye.
Okay.
Yeah.
So now next amendment is related to insolvency law. That is a voluntary liquidation process. Manoj, can you just explain this? Then I will request Madan sir to further develop on this.
Sir, this is also the amendment with respect to voluntary liquidation process is more clarificatory than any major changes. Basically, the law itself says that we have to make the liquidator who is appointed as a voluntary liquidator should seek claims from all the stakeholders and then make a list of the persons who are claimant to any company, corporate debtor. For which voluntary liquidation is being made. So it is saying that the list of stakeholder within liquidator has to prepare the list within 15 days from the closure of that newspaper advertisement. 30 days ka jo notice period hota hai. So that will be the final list of the claimant. Government want this process to be completed as fast as possible and timeline to be squeezed. So practically, we have seen that the voluntary liquidation process goes on for even many cases 2 years. So they have made certain several changes. One circular with respect to income tax was also issued last November, which says that liquidator must not wait for no objection or no dues from the income tax department, which was one of the biggest reason for delay of the liquidation proceeding to be completed. So now this clarification says that whoever has not sent or not filed their claim, they may not be considered for the purpose of making the list of claimant, and the liquidator must proceed further.
Okay. So and 270, yeah, Manoj.
Yeah. So the next amendment is basically it is emphasizing the timeline that the liquidators should endeavor to complete the process within 270 days from the liquidation commencement, and where the liquidator have approved the resolution under 59(3)(c), 90 days from the liquidation commencement date. In all other cases, basically it is basically all again saying the same thing. The timeline should be curtailed and made mandatory within must be finished as soon as possible. So that is the key intent of all the amendments.
Okay, now Mr. Madan, what is your take on this? And then you can cover up some important aspects of the voluntary liquidation.
As far as these amendments are concerned, Manoj has covered briefly all the amendments. But there are certain issues with these amendments also. Now they have said that liquidator shall prepare a list of stakeholders within 15 days. Earlier it was 45 days. According to me, 15 days is too short a period. Rather, we wrote to IBBI also that this 15 days period should not be introduced. Because if we see the cases of other matters under IBC where the claims are required to be filed, there are timelines for filing the claims. But if a stakeholder who has not been able to file the claim and if he approaches adjudicating authority immediately condones the delay and grants him time. Sometimes we have seen even when the resolution plan is pending before adjudicating authority for approval, somebody is approaching adjudicating authority and NCLT is granting them the time, okay, now accept this claim also. Now, under such a scenario, providing this small window, a very small window of 15 days to prepare the list of stakeholders, though it may look like the ease of doing business or the government wants to curtail the delays, but actually it seems to be very, very difficult. I'm not saying practically impossible, but it's very difficult to implement. Then they have said that proceeds to be distributed within 30 days. This is a welcome step, because once you have sold the assets, proceeds are with you. So proceeds, there is no issue of holding the proceeds with you. You may distribute it within 30 days. Now, as Manoj said, the 270 days, the first line says that liquidator shall endeavor. The moment you use the term endeavor, it becomes discretionary.
Yeah, it is.
So it's not a mandatory timeline of 270 days. And once this timeline is not mandatory, I think the whole process may go haywire. One more amendment has been introduced, that is regarding this compliance certificate form H. Earlier, we have form H in case of resolution plans. We have form H in case of liquidation, but there was no compliance certificate of form H in case of voluntary liquidation. Now, IBBI, via these regulations, has also issued a new form H in case of voluntary liquidation. And these regulations have come into effect from, I think, from 8th of April this year.
Yes.
But not applicable to all the pending cases. But I tell you that all the benches of NCLT are insisting for this new form H in case of pending applications for voluntary liquidation. And this is a welcome step. They wanted to you, and I think on the part of liquidators also who are insolvency professionals, it's good on their part that they prepare this form H, which is nothing but a compliance certificate and submitted with the adjudicating authority. Now, some of the issues are still there in voluntary liquidation, which have not been answered or which have not been taken care of, though they were part of the recommendations and part of the suggestions also. Then in case of income tax, in case of GST, though we have said that income tax, one need not go to income tax, but benches of NCLT, they are insisting for income tax clearance, GST clearance, ROC clearance. And these clearances are not coming. Their lawyers are coming and seeking adjournments on one pretext or the other, and the adjudicating authorities accommodating the lawyers of these authorities. According to me, the regulation should provide that once an application has a copy of the application has been submitted with the whether IT or GST, and if no reply is received, say 7 days or 15 days or 30 days, whatever the timeline, it shall be treated as deemed approval. Or maybe not more than one adjournment should be given for this purpose. So unnecessary adjournments are actually delaying the entire process, which was not there earlier, but because now everybody before NCLT and NCLT, people are getting accommodation. So according to me, that should have been taken care of. Next is some of the suggestions were given to IBBI that what will happen in case there are some tax refund cases are pending. What will happen to the voluntary liquidation application in those cases? Or some appeals are pending against the demand. Demand has been raised, corporate debtor has preferred, company has preferred an appeal. So what will happen to this voluntary liquidation application? How this appeal amount is to be taken care of? Whose liability shall be once the dissolution order is passed, or who shall be the beneficiary once the dissolution order is passed? A clarity is needed on this. Another is that liquidator has to open a voluntary liquidation account in the name of the company. Why a separate account is to be opened? I think the regulation should provide and circular should go to the banks also that existing bank account of the company may be renamed as voluntary liquidation account. so that formalities of opening another bank account need not be there. In some of the cases, we see that when liquidator goes to a bank to open this liquidation account, the banks are asking for NCLT order दिखाओ कहाँ है हमें. NCLT order की जरूरत नहीं है उस समय. अब उसे बैंक्स को पूरा लॉ समझाना पड़ता है. They are not agreeing. फाइल ऊपर तक भेजेंगे जी, फॉर्म ऊपर तक जाएगा. A simple clarification needs to go from IBPI to IBA or Reserve Bank of India. Directions should be given to all the banks and bank branches and the zonal office, regional offices. That such a stupid stipulation should not be there that you come out with a NCLT order. NCLT order तो है ही नहीं. इसमें NCLT order ही एक बार में आता है.
Right.
One more thing, I saw a recent order of I think Kolkata NCLT bench where they are very rightly decided कि कुछ उसमें investment seen which could not be liquidated. And no liquidation order has to be passed. So bench decided all these investments will go to one of the shareholders with the consent of the other, and there will not remain any further investment in the name of the company. So that investment are transferred, and whatever was the amount where that was adjusted, and ultimately the voluntary liquidation order was passed. Then even if I see this 270 days liquidation process, the slide on the screen, complete the liquidation process. I think the clarity is needed on this term, liquidation process. What is the meaning of this term that entire liquidation process is to be completed? Does it mean sale of the assets and distribution of the proceeds?
Yes.
Does it mean filing of the dissolution application? Or does it mean passing of the dissolution order? That clarity is needed, and accordingly the timeline should be adjusted. These are some of my suggestions on this. Thank you.
Yeah, so, sir, regarding this 270 days, obviously it is only up to filing of dissolution application with NCLT, not after that, because nothing is in the hands of the liquidator.
Why not to clarify it? Why to say complete the liquidation process? Simply say the dissolution application needs to be filed within 270 days. Matter ends.
Yes.
Okay, Madan, just tell me, this liquidation process you are handling, what are the problems other than this? They have clarified, they have made a date now sacrosanct, and we have seen other sacrosanct date also which has not reached its conclusion. So what is your suggestion to improve the liquidation, the voluntary liquidation faster? And I will request Amit also, anybody, Amit, Manoj, GP and Sudhakar, Nitesh, anybody can tell what changes government should bring out so the at least corporate voluntary liquidation should be faster.
I think the process, there is no issue with the process. The delay, only the issue is of delay, and delay is on 3 accounts. Number 1, on the part of the tax authorities, the no due certificate. Number 2, the delay of clearance from the ROCRD. And number 3, delay on the part of the adjudicating authority, that is NCLT.
Right.
Nothing is in, yeah.
Do you think this
other than that, there may be like a situation like some tax refund is to be received, or something receivables are there which cannot be distributed. So that can be a challenge.
But I don't know whether Amit may vouch for it, whether any, in my view, some indemnity should be taken from the promoters or the stakeholders who are receiving the money, that tomorrow if any this transaction of this voluntary liquidation is found to be fraudulent or maybe against the interest of the stakeholders, an indemnity should be there that they shall indemnify all the stakeholders of the future claims.
Yes, sir. So for that, I think declaration of solvency ke saath saath, I think they need to give all the board need to give a declaration that this process is not to defraud anyone.
That is a declaration. There is a difference in declaration and
now
indemnity.
for the liquidator, yes, protection of liquidator may be required if certain such cases are coming out.
Yes.
Yeah, absolutely. As far as the voluntary liquidation process is concerned, it's a contractual liquidation. It's not a forced liquidation. So there is a solvency. So interest of stakeholders very well is protected. Everybody gets his full money. There is no haircut as such involved in the voluntary liquidation. Now, if I ask a question as to what are the challenges, so as Madan sir has rightly mentioned, that as far as the process is concerned, law is concerned, I find the law is very simple and seamless. There is absolutely no bottleneck involved in any of the processes. The challenges are only administrative. As Madan sir is mentioning that your delay is because of getting clearances from respective authorities. Maybe either it is a tax authority or something else. And the next best challenge that comes is in respect of outstanding litigations. How to deal with that, although the regulations have been drafted in a manner that gives me at least the interpretation that pending continuance of litigation, the dissolution order can still be passed. But very few NCLTs have taken that stand, and the orders are coming and dissolutions order are getting passed, because intention of the government, if you read the discussion paper in the backdrop in which these amendments have been carried out and the policy that government is advocating all across, that they want to create a fast track closure of companies. And voluntary liquidation is one of the mode that government has found in respect of companies which are solvent to work out. They have studied the companies which have been subjected to voluntary liquidation in past 5 years, and basis that they have made these all changes, whatever we are seeing. And there are, I think, second lot of changes also which government is considering, which they have holded back, and they'll be coming out to cut short this timeline and give a clarity with regard to as to what Madan sir has mentioned. If there is a some liability which is required to be paid later on, which is going to come, can I dissolve the company retaining that amount, that if the liability arises, the payment will be made from that account. If liability does not arises, the money will be distributed in the same manner. And likewise, the receivable, if the tax refund is coming. So maybe your dissolution process is closed pending these certain issues so that the process can be expedited. I think otherwise I'm okay with the Form H changes are also welcome change, I'll say. It really helps you in preparing your application for submission to the regulator. So a timeline and other things are also okay, I think.
Okay.
There is one more issue of change of status of the company on MCA records after dissolution. It has been more than 2 years, this controversy is still there, that who shall approach ROC, whether the liquidator or the company or IBBI. This tussle is still there. You file a form, I think form INC 28 you file, but the change of the status of the company is not changed. It still says under voluntary liquidation. ROC says we want a confirmation from IBBI. IBBI says no,
yes,
why should we
write to
MCA?
IBBI. No, sir,
And
IBBI is writing. IBBI is writing. We have to, liquidator has to submit the order copy to the IBBI. IBBI in turn is writing a mail to MCA, and MCA is then putting the status as dissolved.
Amit, it's not that easy. In number of cases, this tussle is still on.
I know. But I'm saying,
and that is why in some of the orders nowadays it is being written that the liquidator is directed to file Form INC 28 with the concerned register of companies. And I think there should be direction in the order also. Now, a simple sentence likhna na, the ROC is directed to put the status of the company as dissolved company.
Dissolved, yeah.
Let there be direction in the order itself.
Yes,
why all these hassles? And what role IBBI has to play in this, I fail to understand.
Right.
Why IBBI should write to a ROC or
yes,
NC?
Yes. It should be as per the NCLT order itself. Yes.
IBBI has no role to play here.
Yeah.
So now I think the liquidation point, which is the government has tried to do it, certain changes. Now I have few questions which I have received relating to independent director, related party. So I will request Sudhakar to start with this. one question. First of all, one question I have received from public. Section 152(5) state that a person appointed as a director shall not act as a director unless he gives his consent to hold the office as director, and such consent has been filed with the ROC within 30 days of appointment. Does this mean that till the time DR2 is informed, DR12 is not filed, a person cannot act as a director?
No, it is not so. It is not so that, in fact, when you are appointing a director, two things are important. One is he should have a director identification number. Second thing is he should give consent to act as a director to the company. The moment the company receives these two documents, based on that, the company can appoint him as a director. And thereafter, immediately he can start as a director and he can act as well as he is responsible as a director. Rest is only a procedural formalities that the company has to comply with.
Okay.
It has nothing to do with the appointment of the director as such.
Sir, I think the intention of the provision is to stop the backdated appointment. To my understanding, because with this I can take DIR 2 or whatever be the declaration for in the last in the past many years ago, and then I do not file it with the DIR 12, and he can act as a director for the last 5 years. So it's a wrong impression to the public at large that he is not a director, is not coming on the MCA portal, but he's still acting as a director. The intention is here to plug this backdated appointments.
Less than 30 days time that is given, that is meaningless.
Yes.
Okay. Okay.
So I agree, the language of the provision of 152 is like that only, as the person who has raised this query has asked. It says that it gives the impression that DIR2 filing is a precondition for allowing a person to act as a director. Though what Sudhakar sir has mentioned, I am in complete echo with the views what sir has expressed. Otherwise, it is impossible to function.
But अगर backdoor entry बंद करनी है, why not to make a provision that within 30 days form DR12 has to be filed, no extension, no additional fee. That's all. Backdoor entry.
That is also there present.
No.
That is the intent, sir. That is the intent of this provision.
No additional fee in case of first appointment. Let it be filed within 30 days. Otherwise, he will cease to be director.
No, let me add one more thing. Why this consent is to be filed with ROC? In fact, earlier what used to happen was there were some people who have been appointed where this act, the filing of the consent was there in the good olden days only for public companies. That Form 29, if I am not wrong, that was to be taken, which is to be filed with ROC. It was not mandatory for the private limited companies. Several times it happened that without the knowledge of the people, they have been appointed as director of the companies. And subsequently that went into a litigation and all those things. I never given consent to act as a director and I have been appointed as a director. I think that is the thing what it was to be, remove that kind of issues. And in the new act, they said that the consent is mandatory and that is to be filed with ROC also.
Okay. Okay. Sudhakar, I have received some questions on independent director. So I'm asking you, can ex-promoter holding 0.1% equity of listed company be appointed as independent director?
See, the relaxation what has been given, see, number one, shareholding is not coming on the way of appointment as an independent director. Okay, that, if a person is already having some shares, he cannot be appointed as an independent director. I don't think that kind of restriction is there as such. And you are talking about the promoter. Promoter cannot be appointed as an independent director at all under 149(6).
Okay. Even he was a former promoter.
Yeah, even if he was a former, correct.
Okay. So, any other different view? Okay, now, Madan sir. Huh?
I can't afford to go against Sudhakar.
Achha, will the provision of independent director apply to a private company where it is voluntary choose to appoint an independent director? The point is, independent director is not required to in the private company, but they are appointing. So the question is, if I'm appointing, then I should follow the rules, or I can say wherever it suits me, I'm following. Wherever it is not suiting, I'm not following. And when issue is coming, I'm saying it's not applicable to me.
In my view, I have a view on this that these provisions are applicable mutatis mutandis.
So it means compulsory if you are appointing, if you are saying independent director, then you have to follow the independent.
That's why mutatis mutandis, where it's not practically possible to be implemented, certainly it will not be implemented. Otherwise, where they can be implemented, they shall be implemented.
In fact, you see that Pawan here, I will take slightly a different view, because for private limited companies, it is not necessary to appoint the independent directors at all. In case of public companies, if they are listed or falling in the class of public companies, they have to appoint. So maybe I may take a view that in case of public companies, even if they are not required to appoint independent directors, still they are appointing it. They may have to comply with 140. I mean that independent directors are relating requirements. But in case of private limited companies, it is very clear that there is absolutely no requirement at all as far as appointment of independent directors are concerned. There I may take a view that they don't need to comply with it at all. It is only a kind of fancy designation, I can say that. To what's called strengthen my argument or my interpretation, I can always say that if I am appointing a person, in the good olden days, we used to appoint as directors, though they are not on the board, but they are only given a designation as a director. Does that mean that person has to comply with all the compliances related to the directors? Answer is no. I may draw an inference from there as far as appointment of independent directors in case of private limited companies are concerned. They don't need to comply with the provisions of Companies Act as such.
Okay. My submission is a company should not take advantage of this, that a private company is willing to appoint an independent director without complying with the provisions, but the independent director wants to take the advantage of immunity provisions. So that shouldn't be the intention. If you want somebody to appoint somebody as independent director, he should adhere with the legal provisions.
No, Madan, I'll tell you a practical example. Some of the people are following this, that some companies are appointing as independent director, and why they are appointing independent director? Because they want to take advantage of certain things. But when issue is coming to follow the principle, then they are not following this. So you are absolutely right. And I was in one company where I have resigned. That was a private limited company, and they appointed us as independent director. And when we appointed as independent director, so they were not providing that information to us which we require. So they're saying it's not applicable to us. So the point is very, very clear. If you are appointing in a company which is not required to have independent director, but you are saying that these are the independent directors, that you have to follow the rules and regulation which you are rightly pointed out. Okay.
I feel a clarification should be there from ministry that if a company which is not required to appoint an independent director, or for that matter, any person, maybe the same issue arises with regard to the key managerial personnel also, 203. If at all they are willing to use that designation, they should comply with full law. Because designation is important. If you are holding out to the public that you are so and so, then you can't take the shelter that no, because I am private limited company, I can appoint anybody.
Yeah, absolutely.
You can't do that.
Okay.
I give a practical example. I received a query that a company is not required to appoint a company secretary, but the company appointed company secretary. So will that company secretary be treated as KMP or not? My humble view was he shall be KMP.
Yes.
See that Pawan, only one thing I want to submit is, I mean, GP is an expert in this particular thing. By merely calling a person, by merely giving a designation, law will not change. Suppose if you are calling a person who is to whom the law is not applicable by merely an independent director or something like that, will you make the company liable that you have to comply with all the related provisions? According to me, answer is no. If I go to GP that tomorrow, if I am in trouble, he will argue the way I am telling him.
Yeah. Okay. Now, Amit, does the independent director lose independence if he has a related party transaction with the company which is an ordinary course of business and arm's length?
Not at all.
Any different view? Manoj?
Independent director is not prohibited. Even if he is a related party, he cannot enter into a transaction. It is not prohibited as such. He can enter into, and whatever the compliances are there, they have to be complied with.
Okay. Madan, some questions relating to your voluntary liquidation has come. The places delay was mentioned by one of the panelists. Why not we suggest that they have to provide the NOC within prescribed period, default of which they have no objection is inferred.
This is what is suggested. I said it. A time window should be given, otherwise it should be treated as deemed approval.
Sir, the practical thing is even in case of merger, 230 also says that the NOC should come within 30 days, and if nothing is coming within 30 days, it will be deemed approval, deemed no objection. But obviously, adjudication authority will not consider this as a final view. They always take care of the regulatory authorities and accommodate the lawyers appearing on their behalf.
This is they are taking a view.
Yeah.
Okay.
मैं adjudicating authority बोलती है हमारी भी तो कुछ powers हैं. Let's exercise those powers.
Okay. Similarly, the adjudicating authority should be bound. Okay. Where is the question of liability once claims are submitted, Madan?
What?
You have mentioned now.
I think this question is talking about some contingent liability which get crystallized later on, like some dispute is there or some litigation is pending before some court of law, and it gets crystallized at a later date. So till the time it is not crystallized, how can a party file a claim? They will file the claim only when the decree is in their favor, or let's say it is a tax demand which is crystallized at a later date. Then that time company may have already liquidated or dissolved. So for that there is a specific provision. Protection is already provided, obviously. So
okay, Mamit and Madan, because it is you are there and night practicing. Somebody has suggested similarly, adjudicating authority should be bound by some time frame and frequent adjournment should be avoided, and without any material valid reason. There should not be any delay and shall be completed within the prescribed period, default of which the end has come by fiction. I think he's suggesting that with some logical reason should be there.
IBVI has already shown the data that not a single case of even operational creditor started insolvency proceedings commenced within the time frame. So not a single case yet. 14 days is the given discussion.
IBC provides that the application under section 7 or 9 shall be admitted or rejected within a period of 14 days from the date of receipts.
Yes.
And not even a single application has been adjudicated upon within 14 days.
Okay. Amit, when you were saying that shareholders, one question has come now that now it is not, they will not provide the shareholders address, telephone number or email address. So somebody is saying the information of the shareholder should be shared after taking consent from the respective shareholders. But if this is the thing, then suppose Reliance has to take it, so they will write to everybody and then they will do. So they it will not open up the Pandora box.
I think as you suggested, there should be some other alternate mode, if at all that is a requirement for reaching out to that particular shareholder. If some shareholder want to reach out, the government should think of some other mechanism, but certainly this option may not be practically viable for the large corporates, especially like Reliance and the others. It may be practically very difficult to implement.
Okay, one suggestion somebody has given backdated appointment like the DIR. So backdated appointment should be curtailed was the intention of that provision. From the wording of this section, filing of the form is prerequisite to function as director.
That's correct. As Nitesh was also saying, that intention of the law was perhaps like, if I give the example, there is a form PS3. When you are doing a preferential allotment or a private placement, the law says that utilization of money can be done only after filing of PS3 form. That is, after you have filed the return of allotment, then only you can utilize the money. The intention is that the filing should happen prior to release of the money from that bank account. So similar to that, perhaps the intention of the government was also here in case of director's appointment, that those documents should be available in the public domain prior to he start acting. But practically it is not getting implemented unless and until government modifies this particular provision, saying that the person will act upon director only after filing of DIA 12, as they have done in the case of PS3.
Okay. One question somebody has asked: in case of transmission of shares, will survivor certificate plus no objection from rest of the survivors suffice, or succession certificate is mandatory?
I think it's a big debate. The law as it stands today, up to a certain amount, the registrar and transfer agent and the companies are not asking for your succession certificate or the letter of probate. But beyond a particular amount, the succession certificate and probate is required. I think Anjali can.
Yeah, but in my view, registrars are asking in every case, they're asking for the succession certificate.
I mean, it's not possible. You know, who has fixed this limit? Nobody can fix this threshold limit. It's the shares are like any other asset.
Any other asset.
Like any other asset, you need a probate or a succession certificate. Same thing is required here.
Okay. Next is filing DR 12 is not only for appointment but for any change, etc.
Yes, absolutely.
Yes.
You are appointed as an additional director, your designation changes to a director, form DIR 12 is required. You are appointed as a managing director, or you are appointed to a chairman position, then again DIR 12 is required.
Madan sir, question for you. CS appointed by company through appointment of CS is not applicable to the company. Will CS be required to file DIR 12?
In my view, yes.
Any other person?
Yes.
Nitesh, Amit?
What designation he is being given? If he is not company secretary, he is just a manager finance or manager corporate affairs, then why?
Okay.
Yes,
so
depend on the.
He says he is appointed as company secretary. This is what the question is.
CS is not applicable to the company, but here will CS be required? They have appointed without requirement.
In fact, here also again the same thing is there. It can be taken a view that when the mandatory appointment is not there, you are voluntarily appointing a company secretary, whether the form is to be filed or not to be filed. So when you don't require, you are appointing a company secretary, what is the intention of that particular thing? And second thing is that you are not filing the form. By merely filing the form, I don't think he is getting any extra recognition. By merely not filing a form, he is not losing the recognition. I am very clear as far as filing of the form is not changing the status, changing the liability, changing the authority.
I think
a procedural issue, you know.
Yes, yes. Sir, whether they are following section 203 or 3204, that is important. Whether he's a KMP and he will be acting as KMP, that is important. So board decision is important.
Manoj, in fact, some professionals argue that when I am appointing a company, suppose CFO, 203 is not applicable to me. I am appointing a chief financial officer.
Yes.
They say that per se chief financial officer is a company secretary. Sorry, he's a key managerial person. But where is that? Because the moment it is he is treating it as a key managerial person, he is to be appointed by the board of directors, giving that he is being appointed as a key managerial person, and that resolution is to be passed at the meeting of the board of directors.
Yes.
So by merely calling a person, by merely giving a designation or calling a person, the law is not getting changed.
Yes.
By merely filing the forms, again the same thing, law is not getting changed. So filing of the form is only a procedural issue according to me. Whether it is required or not, the law is to be complied with. I am very clear about that.
Yes, I also of the same view.
But I am of the view as per section 2, subsection 51, whether a company, the moment a company appoints the executive listed in 251, whether 203 is applicable or not, they are KMPs. I am of this view.
You see that, in fact, GP, if you say that rule 8A, if I am not...
These are personal views.
One minute. I am coming there only. There are companies which don't require to appoint a key managerial person under 203, but they may have to appoint a company secretary, provided the paid up capital is 10 crores plus. So whether there the company secretary is a KMP, answer is no.
Yes, he is.
Answer is no. If he is to be treated as a KMP, then the 203 is to be complied with.
No. So I have a different view. I have a different
This is a point of argument.
Yes.
I say there are the way, in fact, in the companies that you may appreciate that there is a scope for interpretation. There are certain areas like this. In fact, it is always advisable for, maybe corporate professionals can take these kind of issues, take up at a suitable opportune time with the ministry. And especially this kind of times, where company law committee has given its report and I'm sure that another amendment of the act is in the offing. So these kind of issues can be taken up, certainly.
Right.
Absolutely, because 2 clause 51 is one provision which gives a confusion, because as soon as you fall in the category of 251, you become key managerial personnel. That is what creates a confusion, because maybe I am not 203 person, does not matter. I am not appointed as a whole-time company secretary, but you are certainly a key managerial personnel because of 2 clause 51 and section 170 read with rule very clearly says that whenever you are appointing a person as a director or a key managerial person, you have to file DIR 12.
See, Amit, one more thing also.
One
more thing also says, for example, a company may have 3 managing directors. And when they are appointing, that point out, the company can pass a resolution that Mr. A, B, and C are appointed as managing director. Only in case of Mr. A, he is appointed as a key managerial person.
Key managerial person, yes.
Then what will happen is, only because the company is complying with 203 provisions, and only Mr. A is a KMP, and A, B, and C are not KMPs.
Yes.
So there is a fine distinction is there. It can be argued, as I was mentioning to you, and every one of us can have our own interpretations, can have our own issues. Whenever the question comes for what's called as before the law, it can be argued either way, depending upon the circumstances and all. Who may win, who may lose, we don't know. That point, it depends upon that. But yes, there is a scope for clarity to be given by MCA on this particular issue.
Sir, you are mute.
Pawan sir, you are.
Okay. I think the question of contingent liability should not be arise in voluntary liquidation, since creditor approval is prerequisite to initiate the process. So this is somebody.
Contingent liability is something different. Let us understand. Let us say there is a GST. GST has gone into, department has gone into appeal. So you don't know how the appeal will be decided. All the matters where the litigation is going on, there the liability can always be contingent.
Yes.
So these are all issues.
Yeah, yes. And in such cases, liquidator would not accept the liability claim even if they are filed that time. But if it is crystallized at a later date, naturally it has to be admitted.
Okay.
At the time of filing the application for dissolution, if these liabilities are still contingent, the provision has to be made for that before passing the dissolution order. That is what the difficulty is.
Yeah.
Okay. So the next last question.
Sir, I think I was just highlighting. I think we have covered a lot of amendment. There is one circular issued by NSE on 25th of April on the related party only. We have covered one circular of 8th of April, but we, I think, missed out one very important change that is from NSE on related party. We can cover, I think there are some FAQs which are released by NSE and BSE both.
Yeah. Amit, you can tell us.
So I can just flag the issues where difficulty is that what this circular is all about. This circular is primarily attempting to give a clarity on the XBRL filing in form in respect of regulation 23(9). As we know, related party transaction details are required to be submitted from September quarter onward in the XBRL mode. Now, NSE has came out after this 9/11 amendment in respect of these clarifications. I'll just read the 3 clarifications which are of most importance. The first question that was raised to NSE was, what does, where the transaction is undertaken between members of the consolidated entity, between the listed entity and its subsidiary, or between subsidiaries, it may be reported once. In point number 2 of notes in new SEBI format means? Answer that they have given is all related party transactions entered into by a listed entity and its subsidiaries must be reported. Now, while I am reading this answer, I am getting confused, because if we read 23(9), prior to 1st April 2022, where it was mentioned that the reporting has to be done on the consolidated basis. Now this question becomes very relevant. What is the meaning of reporting on consolidated basis? Are we saying I have to do the reporting on the consolidated financial statement basis, or I have to do reporting on the basis of consolidated groups, like holding company is one group, subsidiary company is one group, associate company is one group, directors are one group, relatives are one group, and key managerial persons are one group? So are we saying that because if I have to take a view which is prevalent by and large in the industry has taken a view in the last 5-6 years, since December 2015, when the provision got introduced, I think little later, the industry has taken a view that I have to give the reporting on consolidated financial statement basis. So if I am doing a reporting on consolidated financial statement basis, then my subsidiary transactions are knocked off. My consolidated statement will never contain the details of related parties with my subsidiaries. If in that backdrop I read this clarification, I don't understand for 31st March 2022, why at all a listed entity will be required to report transaction with its subsidiaries, if that is the view. However, if the view was different, that I mentioned that if it was to be done on a consolidated basis, that was meaning that subsidiary company one basket, associate company one basket, and I have to consider standalone figures only. So my question to my co-panelists is to give a clarity. What is the correct way to understand 23(9), whether the reporting was to be done on standalone financials or on consolidated financials?
Sir,
Maybe Anjali.
Sir, if I go about that corporate governance norms, and the intention is to disclose each and every related party transaction, so we should not consolidate like we are consolidating in the financial result, because every company is before this amendment came into picture, when it was recently initially introduced. Now all the companies are making the disclosure same as disclosure made in the financial result. They are grouping, the grouping was made like holding companies, subsidiary companies. So they are making disclosure like this, but that is not the intention. If I want to know with the X subsidiary, how much transaction I made, if I want to know, I cannot get that information. And the corporate governance norms should also be in such a way that every related party's transaction should be, the transaction in the whole year should be disclosed on a half-year basis, should be disclosed to the shareholder. Rather than a consolidating, it should be on a standalone basis per related party, considering the governance norms in hand.
I understand, Nitesh, what you are saying is applicable from April 1, 2022. We are talking about reporting that is required to be done on 31st of March in respect of transactions, what the half year that has closed on 31st March 2022, when the law was old. Whether it has to be done on the consolidated financial statement or standalone financial statement is the question.
Okay.
It should be on a standalone. It should.
Amit, few questions are there. I just want to finish this. Okay. Somebody is saying that if you convert the partnership company into company under section 366, ROC is not issuing any certificate. It is a problem. Is it correct? And how to solve this?
No, ROC is issuing a certificate. The only challenge that is coming in 366 conversion is nowhere it is appearing that it is a conversion. a plain vanilla certificate is coming, your history is not coming. Let's say I am Amit Gupta and Associates. I converted to Amit Gupta and Associates Private Limited. Then there should be a legacy that this is a conversion of Amit Gupta and Associates. That is not coming. That is where the difficulty is. So I think that demand is genuine, but ministry so far has not been able to accede to that demand, and they are issuing a plain vanilla certificate without mention of their previous status.
Okay. One gentleman has requested that all seniors to kindly raise the issue before the respective authority. Yes, Adit, whatever questions you are sending and whatever issues we are discussing, we are consolidating and sending to the ministry, SEBI, RBI or Insolvency Board where it is there. Okay. Now, just to complete IVC within time limit, it is justified for NCL to pass order without hearing both the parties. In one case, both CD and OC were not present. Although earlier the OC appears 2 times with no one from CD. The bench passed admission order. Rule of Audi ultram petrum not followed.
It means principles of natural justice have not been followed. It's nothing a new case. Go to NCLAT. This order will be set aside. First of all, it will be stayed and that will be set aside, not an issue.
Okay. Okay. I think we have covered all the questions relating to this. And friends, we are making this program as a part of our webinar every week up to the first Friday. Whatever amendment has come, we want to discuss, and we want to discuss in the same way. First, we will give a presentation. What is the law? We want to discuss that because of this law, what will be the impact, and what are the issues in this. So the modus we have adopted, it is absolutely right that we have completed all the issues which has come during this particular month. This time the issues was less, but questions were, I think, more than 40-45 questions. So we can understand. So this model we will continue. The first program of the week will be of the same. So anybody has any query relating to these circular which has come, you can write to us. We will include, and then we will deliberate and submit to the regulator that no doubt you have come out with this particular thing, like this 366 issue is somebody has raised. So all other issues we can refer it. And I request all the panelists also. So whenever you are participating or you are finding any issue when you are reading the new law, please pass on. If you are confused, it means other people are also confused. So it is better that we should write to the government and tell them that this is the issue where we are stuck. It's not a clear. No doubt it will reduce the workload of Mr. Madan or Amit, because if you clarify everything, then what is there for to interpret it. But anyway, because I think so many things are there where the corporate world is facing. So it is better. All small issues should not be there.
But Pawan, I must say that I compliment you and corporate professionals for this format, which is very much required, because several times it used to happen that whenever any amendment comes, immediately there is a discussion starting on the WhatsApp groups. Whereas here it is a very structured manner you are doing it, and it is a commendable initiative, I must say that. My compliments to you.
And we will continue this. So today the people are not aware because they are thinking this is a normal program. But after some time, if in the month they have not studied anything, so all the people, those who have not studied or those who have left out any circular, we are covering everything. Something which was missed out, Amit has covered. Okay. So by this way, you are getting all the information updated, number one. Number two, the information which is given by, or circular which is given by the government, it has some issues. So interpretation is also there, so that all the experts are discussing. Third issue is that experts are also creating some confusion. So if they are confused, it means other normal public is also confused. So we want to settle by discussion.
Experts are not confused. Experts may have different views. They are not confused.
Maybe Madan, because those who have to file forms, those who have to file paper, those who have to submit things, they want clarity. because they are confused sometimes.
Very simple, Pavanji. Whenever you have doubt, file form or not file it.
Yeah.
Better to buy peace.
Okay. And then if there is a confusion is amongst all of us and we are also different view, then we are writing to government to clarify. So by this model, we will continue every week. We will do this program, and we will every first Friday of the month we will do this program. So thank you very much, Sudhakar. Thank you, Madan. Thank you, Amit.
May I, for 1 minute, I want to, because some of the participants are still here. There are two burning issues nowadays. Number one, recently, Ministry of Corporate Affairs has given permission to all the ROCs to initiate disciplinary file complaints against the professionals. And now all the ROCs have preferred complaints against the professionals before their respective institutes. Ashoka's notices have been issued by the institutes. Anything we need to analyze that what sort of complaints are these, what are the issues, and if we can come forward and discuss these issues so that in future, we the professionals do not commit such mistakes if we have committed in past. Secondly, that SFIO nowadays has become very, very active. Number of complaints, number of cases have been filed now, SFIO. In each case, not less than 100 respondents are there. And in some of the cases, these respondents are none other than but the professionals. Maybe it's a time, it's an alarming bell for all of us, and we need to be very, very vigilant in our professional work and our professional assignments. Maybe a couple of events we can have on these issues also, that what are the issues which have been raised by the ROCs and by SFIO.
Okay. Okay.
Absolutely necessary, I think.
So thank you, Anjali. Thank you, Manoj. Thank you, Nitesh. And thanks all participants, those who have come. Thank you very much. Thank you.
Everybody.
Thank you. Thank you very much.
Okay. No, I'll just. Next Friday, we are having a program on buyback. So the buyback versus dividend, buyback new regulation, buyback by tender route, buyback through the market purchase. All these issues we will discuss, and we have requested regulator SEBI also to participate in this, and Anjali will lead this discussion. So there is always confusion that whether we should give dividend. Is there any alternative? Because dividend is 42% tax. So buyback is one of the method to save tax also, and they increase the value of the company also, and improve the EPS and other thing, which big IT companies are regularly doing. So we will all discuss on this next Friday, same time, 4 o'clock, and we'll discuss this. Thank you very much.